On the issue of firearms bans for people who possess or use marijuana, under federal law, a person who is a habitual user of any controlled substance cannot possess a firearm or use a firearm. It's 18 USC 922G if you want to look it up at home. And of course, marijuana is a federally controlled substance. So regardless of state law, the federal law says that you can't possess a firearm. So even if it's legal in state law, the feds don't care because it's illegal federally and makes it illegal to possess a firearm if you're a habitual user. Well, the court's looking at this. Some courts are like, that doesn't quite make sense. And a different federal court has ruled that this is unconstitutional. So a additional federal court, because it's not the first one, has ruled that banning people who use marijuana from possessing firearms is unconstitutional, and that would also apply to sale and transfer of guns. Different courts attempting to defend the cannabis ban have run into this issue, and arguments have faced increased scrutiny in light of broader protections for the Second Amendment. The Western District of Texas has added its voice to this growing issue, delivering a win to an El Paso resident who was convicted of separate charges of possessing and transferring while admitting to be a cannabis consumer. The judge granted the motion for reconsideration and dismissed the charges. While the court previously issued a conviction, it said a more recent ruling from the Fifth Circuit warranted reevaluation. That case relied on U.S. precedent finding any firearm restriction must be consistent with historical context. So this woman had already been convicted, but then the Bruin decision happened, and the Bruin decision is causing a lot of courts to reevaluate. So the Fifth Circuit, which Texas is in, issued some revised guidance, and the court was like, wait a second, maybe we need to take another look at this. So her case hadn't become finalized yet because it was still going through the appeal process. And so her case was remanded back to the district court for further consideration. And the district court's like, you know what? How about not conviction? How about conviction just set aside and go free? Case dismissed. So that's nice. For the latest federal district court case, a Bush appointee disputed the Justice Department's attempt to make historical analogs to marijuana ban, including comparisons to laws while using guns intoxicated from alcohol and possession by people deemed unvirtuous. The court said that because simple cannabis possession would only be a misdemeanor, any historical tradition of disarming unlawful individuals does not support disarming this particular person. And also, of course, President Joe Biden recently issued a mass pardon for people who had been convicted of marijuana offenses. But this particular person wasn't a convicted user of marijuana. That wasn't the problem, which also might be a disqualification. It wasn't that they had a conviction for marijuana. It was that they're a user of marijuana, which is a separate provision in 922. So if she had been convicted and no longer using marijuana, her conviction would have been wiped out. But because she continues to use marijuana, the pardon is irrelevant because she continues to violate federal law. But the court pointed out that this didn't make sense because the longstanding prohibition on firearms by felons requires the government to charge an individual. And so that didn't make sense. In short, the historical tradition of disarming unlawful individuals appears to mainly involve disarming those convicted of serious crimes. 922G3 would disarm those who engage in criminal conduct that would only give rise to a misdemeanor without affording them procedural protections and thus deviates from the historical firearm. So the issue is twofold. First, this doesn't require you to be convicted. So you're being stripped of a right without a conviction. And even if you were convicted, it's only a misdemeanor. And so therefore it wouldn't qualify as a felony prohibition. The court went on to challenge the government's position that cannabis users are intrinsically dangerous, adding that over 20 states have legalized marijuana, and it strains credulity to believe that taking part in the widespread practice can render an individual so dangerous or untrustworthy, they must be stripped of the Second Amendment rights. The law's broad prohibition on sale or transfer of firearms to unlawful users of controlled substances also burdens the Second Amendment rights of those individuals to nearly the same extent that 922G3 did, and the court found that this history and tradition does not support placing this regulation in place. This is one of at least 4 active federal cases where government marijuana and guns policies is in question. So, an issue that is continuing to circulate as it relates to this issue. So, should be interesting to see how that develops.